It's right here, Judge. It's the one you handed me earlier. It's an unindicted case.
What are we doing?
It's a red hearing.
For bond reduction.
Is that through the ones? Yeah, it's a little bit.
Okay, where is the charging instrument?
It's not indicted, Your Honor.
Was there a complaint though filed?
Right away, the courtroom feels disorganized. The judge is searching for basic paperwork, and when a judge starts asking, "Where's the charging instrument?" you know this hearing is already off to a rough start.
No, all we have is a PC. We have a prop. That's all we have.
Is that it?
I don't know. Is this a writ or what is this?
Yeah.
Yeah,
The case hasn't been indicted.
it looks like a pre-indicted case, but I'm looking for, isn't there normally a complaint?
The only thing I was provided was a probable cause affidavit.
And that's all I'm showing up here, but there's a charging instrument, isn't there?
No.
No.
There's
Could be
you got
I don't know if
probable
there's.
cause affidavit that supports a warrant for his arrest.
Sir?
I don't even see a warrant for his arrest, but I'm sure one was done. And I have a public safety report, by the way, which is always required, that shows no criminal history.
Yeah.
Only this deadly conduct on March 16th, which is represented by this probable cause affidavit. Okay, this is the Rogers Park situation.
Yes, Your Honor.
Terrible situation. What do you ask? What's the bond now?
$500,000.
Why not?
Well, Your Honor, Mr. Perkins has been in custody for 45 days at this point.
Here comes the defense strategy. Argue that the $500,000 bond is excessive because the defendant has no major criminal history and no financial ability to pay it. But in cases involving public gunfire, judges usually care more about public safety than personal finances.
Point, in this case, is still not indicted. His family has tried to secure the bond at the current amount. We do believe, based on the average prior to this incident, or the average for a third-degree felony deadly conduct, that this current amount is excessive. Mr. Perkins does not have the assets or any type of property that he will be able to sell in order to obtain the funds at the $500,000 amount. And based on him being in custody for this amount of time, we believe that a bond reduction is necessary at this time.
State?
Judge, there were numerous people at that parking in that area that had to run for cover and hide. This may be a third degree, but it could have been worse.
The prosecution is leaning heavily into fear and community danger here. Families running for cover, shots fired in a public park. They're building the argument that this situation could have turned deadly in seconds.
It's just lucky that shots did not hit other individuals and make it worse. So you've seen the response from the community in this, that they're terrified because of the violence, and this is reaching out into a public park now to where innocent people were just standing around just having family time. So we would ask that bond stay the same, if not be raised. I can't ask for it to be raised because I don't have enough information, but I just don't think it should be lowered.
And I'm sorry, one more thing.
Yes, sir. Yes, ma'am.
I did contact the detective on this case, Detective Cormouch, at the beginning when Mr. Perkins did go into custody. We have been provided information in regards to Mr. Alexander Perkins and in regards to him not actually having a firearm at this time. Obviously, that is an issue that we are going through with law enforcement, but it is our intention, if this case is indicted, it is our intention to fight the charges in regards to Mr. Perkins not even having or discharging a firearm on that day. And we
Okay.
do have witnesses on his behalf in regards to that.
Today?
Not today, Your Honor.
Anything else? I have four corners of this probable cause indictment, probable cause affidavit to go on, which in summary states that on Sunday on March 15th of this year, last month at approximately 6 o'clock in the evening, Beaumont Police Department and other law enforcement people were dispatched to Rogers Park in reference to multiple shots being fired there. Officers located spent shell casings at the scene, which indicated that multiple firearms had been discharged in the area, as the bullets apparently were different calibers. And during the investigation, eyewitnesses positively identified Alexander Perkins and Dante Perkins as being among the individuals who were discharging the firearms. And
This is the moment that likely sealed the defendant's fate. Prosecutors say eyewitnesses identified both brothers firing weapons in the park. Once children and random bystanders are part of the story, judges tend to get extremely tough.
based upon the evidence from the scene and eyewitness identification, the investigators state that there was probable cause to believe that this defendant, Alexander Perkins and Dante Perkins, is Dante your brother?
Yes, sir.
Knowingly discharged firearms in the direction of an area where individuals were present, thereby recklessly engaging in conduct that placed others in imminent danger of serious bodily injury or death. Could have been a catastrophic event. Do you have information of how many shells, bullet shells were recovered?
Let me see if there's.
I'm looking at the defendant's criminal history, and I don't see anything from this public safety report except charges that are arising from this March 16th event. This is a park. It's bad enough. It's a city. And we all know that things happen in a city when people make foolish errors, especially when you have a firearm. When you shoot a firearm, you don't know where that bullet is going to necessarily end up, and it is used to kill. You have a location here at a park where children predominantly go. Children. And y'all are going to be involved. People are going to be involved in shooting irresponsibly bullets in a park where children can be placed in harm's way, plus other humans. We all know from what this court has learned that there were numerous bullets shot, and that not only were bullets, shells found in the park, but also apparently bullets were discovered in locations outside the park where they landed. When you shoot a gun, you don't necessarily know where it's going to land, but it can cause death and serious bodily injury. And when you're at a location where predominantly children go, shame on anyone who is responsible for that. The probable cause affidavit states that information from the police show that this defendant and his brother are positively identified as being among the individuals who were discharging firearms at this location. Irresponsible behavior. You won't get a reduction from me $500,000 may, as the state says, be too.
And there's the ruling no bond reduction. In fact, the judge hints that $500,000 might actually be too low considering the risk to innocent people. That's a massive statement and shows just how serious this court views reckless gun violence.
Little. They don't have information to provide for the court, for this court to raise it. But I am, in spite of the fact that your attorney does a valiant job in all she does, everything she does, Ms. Holmes, in due respect, I'm not going to grant a reduction in this bond, and $500,000 may be way too low when lives, especially children's lives, are at stake. Do you understand what I'm saying? So, okay, anything else? That is all.
Thank you.
Okay, how are we on probation? Don't be, I'm sorry, this is a court. Do not making outbursts. You will be arrested immediately. Thank